This is Professor Porter. The course is called Trial Techniques, and we're in Chapter 2, Trial Advocacy Generally. And this is a tough subtopic right here, theme. I think most people understand what we talk about when we talk about case analysis, that we're trying to narrow the universe of all the material that's at issue in the case and kind of hone down on our trial presentation. And they similarly, I think, can understand case theory. It's a legal theory. The theory under the law as to why we may prevail at trial. So, if you're a prosecutor in a criminal case, you're talking about how you're going to meet the elements. If you're a criminal defense attorney, by contrast, you might have a theory that this person wasn't there, there's an alibi. You might have a theory that some other person did it. This robbery was committed, but it wasn't by my person. There's a clear legal theory that leads to, at least carves a path for prevailing at trial. Theme is different. Theme I want to sort of demonstrate through a process. Imagine that I have a case, again, a criminal case, where I have a scammer from the internet that was essentially reaching out to people, vulnerable victims, telling them they had some connection to some money and offering telling them they had to sort of check in with some type of deposit to gain access to that money. A true scam, offering no services. As the prosecution, I got to think about not only the elements of theft, not only how my case presentation and my witnesses through their testimony and exhibits spell out the elements to make sure that I can meet my burden as the prosecutor to prove the theft, but the theme, I have to think about ways to explain the unique aspects of this case. The fact that it's on the internet, the fact that it involves a scammer and not someone that's stealing something tangible out of a house, the fact that someone's tricking someone out of money. I use theme to essentially explain what's going on in the case or to encapsulate my approach to the case. And I want you to think about my trial team being in a room, and we have our case analysis. We have the witnesses we're going to call. We have the general areas that we're going to get through. We have the sort of closing argument that we're aiming to at the end of trial. We have the exhibits that we want to put in that are sponsored by those witnesses. We kind of have a shell and a plan for our case. Now, that's the script, that's the play we're going to put on. Now I want to try on some of these sort of book covers to it, some movie theater posters to it. How can I kind of sum it up? So I have a couple I'll try. The lure of false hope. I'm thinking of those words, a lure. I'm trying to, essentially a fishing type of thing. He's not discerning any specific victim. He's looking out there and trying to grab victim. I like the imagery of lure. False hope, it's like, I'm preying on victims that hope that they're going to run into money, hope that they're going to have an easy. So I want to try on this theme, this expression, this visceral, this rhetorical tool to help explain my case. And if it's a theme that's going to work, I'm going to, as the person on my trial team that's giving the opening statement, I might want to start with, in this case, you're going to hear about a lure of false hope. You're going to hear about the lure set by the defendant here, preying on the false hopes of the victims, some of whom you'll meet during the course of this trial. I want to vary up the language of a lure of false hope, and I want to try it on. I might, through witness testimonies, once we get to the case presentation, there might be actual answers that come out of witnesses' mouths that talk about hopes or talk about false promises. They might use the word lure. So it's this language that I'm returning to where months from now, my jurors are not going to remember the names of the witnesses. They might not remember the name of the defendant. They won't remember the dates of the communications, but they can remember sort of this phrase or this expression that I've used to explain my case. Oh, that's the case, a lure of false hope. Yeah, I remember that. So something that can last beyond the details of the case to help explain it. And then maybe opposing counsel can think about that and twist it for their own purposes. So we got to think about how's it going to play out for my case? How might the other side use it? There was only one lure in this case, and that's the government. They were lured into, this prosecution, even though they didn't have enough evidence. It can be flipped around. But what I want you to think about is that same framework of those witnesses and those exhibits. I could try on a different one. I don't like that one as much. Empty promise, a full pocket. An empty promise, a full pocket. Let's see as a trial team, let's see what we can do with that. So I might start out again in my opening. I might return to some of that language. I might vary that language as we go first. That was, in these emails, the initial emails reaching out, they already contain the empty promise. But once the victims replied, there were more promises that equally had nothing to offer. I'm varying that language a little bit. And what's it aimed towards? Why is he getting into all these different conversations? To fill his pocket, to make sure his pockets were full, varying that language. So I try on themes and I try out themes and see how the language might work throughout the course of the case. So, it could be an expression, it could be a known quote, it could come from the evidence at trial. It could come from, prospective testimony that is going to come out through a deposition. So we're trying on different themes as we go through our trial presentation, help explain the case and our perspective on the case.